The Colorado Supreme Court was the first to issue such a landmark ruling, citing a post-Civil War constitutional amendment that prohibits insurrectionists from holding office. The court said that Trump had engaged in an insurrection and consequently is disqualified from holding the office of the president. Now, just a few hours ago, Trump's lawyers asked the United States Supreme Court to weigh in on this, as expected. His lawyers say the Colorado Supreme Court got it wrong. They write, quote, "It was not insurrection, and President Trump was in no way engaged in insurrection." They say the question of Trump's eligibility is reserved for Congress, not the state courts to decide. They want the United States Supreme Court to, quote, "return the right to vote for their candidate of choice to the voters." The Colorado's High Court is not the only one grappling with this question. Last week, Maine's Secretary of State barred Trump from that state's primary ballot, and Trump's candidacy is being challenged in 17 other states. The Supreme Court's 6-3 conservative majority is expected to take up the question of whether Trump is constitutionally eligible to run for president, and its decision could reshape the race. Joining me now is Barbara McQuade, former United States Attorney for the Eastern District of Michigan and an MSNBC legal analyst and author of a new book coming out next month titled Attack from Within, How Disinformation is Sabotaging America. Cannot wait to get my hands on that. Barbara, thank you for being here. Donald Trump's lawyers are latching on to something that has been popularized in the media recently, and that is, notwithstanding the Constitution, Section 3 of the 14th Amendment, which disqualifies someone who has taken an oath from running for office, the people should decide. And that's an interesting question because there are many, like Judge Ludig, like Jamie Raskin, constitutional experts who say that's not an either-or thing when it comes to something that's in the Constitution. You can say that the court got the interpretation wrong, but if the Constitution says X, you can't just decide we'll just let the people decide.
Yeah, this is an argument, I think, that has some appeal at a gut level. I mean, we think about our democracy as everybody gets to cast a vote and choose who they want for president. But the Constitution itself is created by the will of the people. Even the 14th Amendment had to be approved by 2/3 of Congress and then 3/4 of the states. And so we created, through the democratic process, the qualifications for being president. There's an age limit. There's a term limit. There's a citizenship limit. And there is also a limit that you not be an insurrectionist. And so these are hard questions. The court is going to have to look at this and decide how to decide this question. But the idea that we just disregard the 14th Amendment and say put it to the people, I think is the weakest argument in Donald Trump's new petition.
So the slightly less weak argument, the one that is actually one that a court can consider, is whether January 6th was an insurrection and whether or not Donald Trump took part in it. The Colorado Supreme Court didn't take the easy way out of this thing. They really examined it. They looked at various ways in which the term rebellion in the Constitution could have been interpreted and giving care and comfort to those who participated and could be interpreted. And they deliberated. They came out with a decision that they said Donald Trump did participate in an insurrection. It's interesting because a lot of the Republican argument is that there's been no adjudication of that matter.
Yeah, I think this is the weakest part of Donald Trump's new petition with, in kind of a single paragraph, he says, an insurrection means waging war against the United States like the Civil War. And since this was instead a peaceful protest that got out of hand, that's something completely different. End of story. I don't think it's as simple as that. I think you have to look at the language. And of course, the Supreme Court in its current makeup is very big on original textualism. And so what was the common public understanding at the time of the 14th Amendment? And there is certainly some debate at that time that said, we want to make sure this doesn't apply just to our current situation with the Civil War, but all insurrections that may come in the future. So it's a hard question, but I don't think Donald Trump's brief tackles it with the seriousness it deserves.
And let's just put some meat on those bones. When this amendment was written and ratified after the Civil War, there was a pretty clear idea of what rebellion looked like because it had been the Civil War. Is Donald Trump's team leaning into the fact that you can't compare January 6th to the Civil War or he didn't raise an army? I've heard all of these sorts of arguments.
Yes. I mean, they say this was not an insurrection. An insurrection only stands if you are waging war against the United States. And even if it was an insurrection, Donald Trump did not engage in it, which is the word in the 14th Amendment, because all he did is give a speech, and that is protected by the First Amendment. So some of those same arguments that we have heard before. Now, one of the arguments I have heard is that due process requires that he be found beyond a reasonable doubt to have engaged in insurrection. And that certainly isn't the case. And even he doesn't make that argument. I think that in most civil matters, preponderance of the evidence is the standard that can be used, and hearsay evidence can be used. And so looking as the Colorado Supreme Court did to the January 6th House committee hearings seems to me perfectly appropriate for determining whether there was or was not an insurrection.
There was a sense amongst those who had been proponents of the 14th Amendment, Section 3, that the Colorado case, there are 17 states that have a view on whether or not Donald Trump should be disqualified from running, that the Colorado case was the strongest. How do you evaluate that? Are they not there? I've heard people ask me, aren't they all equal? Isn't the same Constitution applicable in all states?
Yes, it is. But each of these states is looking at it at sort of a different procedural point. I think people think, and I agree, that the Colorado case is the strongest because they actually had a trial. They brought in witnesses. They had some of the police officers who were there at the Capitol on January 6th testify, and they had expert witnesses testify. In some of these other states, they have either relied solely on the record of the House committee or have decided this on the basis of some procedural issue. So this one seems to be the one that is the appropriate vehicle for the court to look at this question. And I do agree with one thing in Donald Trump's brief, that is, this is a significant public question that requires prompt disposition by the Supreme Court.
Trump's lawyer, Alina Habba, said on Fox News today, said something interesting. She said Trump is deeply concerned that the Supreme Court justices, particularly the ones he appointed, may shy away from being pro-Trump because they're trying so hard to look neutral. Now, I imagine that's not a legal argument, but there's some messaging that's intended to get to these Supreme Court justices to say, don't overdo it. Don't bend over backwards to not look like you're on my side. I don't know how a lawyer with your experience evaluates a statement like that.
Yeah, I think they're working the refs. But I don't think that works. You know, certainly this court has a very conservative worldview. I don't know that they're in the bag for Trump. But I do think it may be easier for them to find some off-ramp to avoid deciding the question. And Donald Trump's brief provides them with a number of off-ramps. For example, finding that the office of the presidency is not covered by the 14th Amendment. Or the other one they raised, which is new to me, I hadn't heard before, which is that the 14th Amendment does not talk about whether someone can run for president, only whether they can hold the office for president. And so all of this is premature. He ought to be able to run, even get elected, and then it's up to Congress to decide whether he gets seated in January of 2025.
Note to self, if you ever get invited to a constitutional convention, that words matter. Barbara, great to see you. I'm looking forward to the book. Thank you, as always. Barbara McQuade.